请到我们学校的这个涉外法律中心的主任郑家杰教授，而且他是美国律师。那么他在我们学校，还有包括在整个台湾的很多涉外法律事务上都有很多的贡献。那我们感谢他今天来帮我们做这个大会的这个 opening。那我们欢迎郑家杰老师 ，Professor Zheng。
Thank you very much, ladies and gentlemen. Very honored to be here to host this session. And today we're quite honored to invite you to great returns in Belgium, Japan, and to the topics on the patent, the transfer, technology transfer. I just, in fact, during the session, during the break, I just had a very nice exchange of opinions with them. And Yves from Belgium, and also have great experience studying in the US. You know, when you talk to him, you cannot exactly tell he's European or American. So his fluency, of course, the language fluency in this field is definitely almost a signal for success in this business. And our dear friend is from Japan. I thought, interesting, I just look at his business card, but I don't see any Japanese there on the card. So I just feel strange. It seems there's another Oriental project that we didn't have the Japanese name here, and all of a sudden I read it carefully, I found out he really working in Germany, and have the cases, the prosecution in Japan. So no doubt, with their great experiences and many years, probably well versed in this field on the patent technology transfer. And very, very honored to have you guys here and to help us to have a great, deep understanding to these specific issues.
Vincent?
And talk about the future, what impact it could have, with the new regime that was just has been passed. So let's just honor their presence with a big hand. So welcome,
Professor Yves Van Couter.
Yes, let's do it.
Thank you very much, Professor John, professors and distinguished audience. I'm obviously very honored to be here and to be invited to give a presentation on a subject matter that is, in my view, extremely exciting. Technology transfers in Europe is actually covering or related to two fields of law. The most interesting ones, on the one hand, intellectual property law, and on the other hand, competition law. Now, what is intellectual property? That's the first question to be answered. And what is the actual goal of intellectual property? It is giving a monopoly. It is about giving exclusive rights to somebody who has been creative, to somebody who has produced a product, manufactured a product, or produced a new service that distinguishes that service from others, that increases therefore innovation. And as a consequence, for that creativity, you get a monopoly, you get an exclusive right. You're the only one who can actually use the right to produce that product and to sell it. Now, what is competition law about? It is about avoiding monopolies, preventing monopolies. It is getting rid of exclusivity and exclusive rights. It is about fostering competition. And why? Again, to foster innovation. So both domains of law have one goal: increase innovation, but with opposite means. Intellectual property through giving monopolies, and competition law by avoiding monopolies. How do we reconcile those two objectives?
好，首先我先请问一下，这边是不是大部分都是应用外语系的同学？需要翻译中文吗？如果不需要的话，我们就让他继续。你觉得有需要吗？还是需要我大致 briefing 一下这个主题？好，我前面先简单讲一下啊。今天很特别的就是说啊，you have to say I have a brief opening that because they say the English is good enough, so we don't have English. 首先我讲一下，大家有没有听到说这个 Google 他买 Motorola 的这个专利的时候，在美国受到那个 FTC 很大的一个这个调查，然后我们知道说这个。比尔盖茨的公司曾经被要求一定要分开，或者是我们知道说，这个中国在前一阵子惩罚了我们大概包括亚洲的所有的面板公司，说他们垄断竞争这些相关的议题。那还有呢，另外就是说我举个简单的台湾的例子，大家知道奶粉有新美丽跟 S26，对不对？然后小时候你们有没有听过 S26给男宝宝，新美丽给女宝宝？你们没有听过，我小时候听过，所以但是我爸爸给我喝 S26。但是后来我到了 S26这家公司去上班之后，我发现一件事，这是两家公司协和瓜分的市场，这件事对消费者是不利的。好，这样你了解吗？还好，接下来呢，大家知道手机的那个影音是不是有个 MPEG？好，那 MPEG 前一阵子跟谷歌协同授权不收费，但是 MPEG 对于另外一个比较小的公司收费，所以现在在技术的移转方面。你应该有哪些的规范不会影响竞争？还有刚刚他提到一件事，专利是为了要保护创新发明，给予发明人独占权，没有专利人、权利人的同意授权之下，别人不可以使用。然后呢，但是也因为他把他的资讯公开给全世界造福社会，所以给他这个独占的保护，然后大家可以获利。但是竞争法呢，又是一个另外一个概念，它也一样要促进科学社会的进步，但是它不希望垄断。那这边的小朋友应该都很年轻，可是这边的老师应该都知道，一开始以前 Internet Explorer 以外，还有一个叫做 Netscape， 对不对 ？Netscape 是不是消失了？所以其实竞争法它的意义在保护创新发明，他刚刚讲过了。然后在违反垄断方面，一开始听到反竞争法，你觉得那你要保护我专利，你又不希望我过度的发展？比如说我以前给我奖学金的公司阿斯利卡。他被欧洲罚了好几个亿的欧元，因为他过度的专利保护。我们前一个 topic 都在专利方面。那我们会觉得说，我做了这么多研究，我可以世界第一名，我发你这么多专利，你凭什么来罚我？但是你是不是相对竞争了其他有潜力的技术，在社会上，在这个整个地球上出现的机会？所以他今天要讲的大概是这个题目。那我们很感谢大家都英文这么样子的好，所以我们让他赶快继续讲到这个议题。然后他另外会讲一下欧洲的观点，怎么样去限制市占率，怎么样去扶持弱小的科技，怎么样达到平衡？这是一个今年5月才刚刚出台的一个欧洲新法案。So welcome, you can continue in English.
Okay.
But a little bit fast because they will close the light, shut down the electricity.
Oh.
At 5, so.
At 5. How late is it?
Okay. So just run through the English version.
Okay, excellent. And I'm sure you got a perfect resume, summary of what I'm going to say, so don't run away. We'll go into a bit further detail on the subject matter. So it's all about balancing, reconciling, on the one hand, the intellectual property law, which is focusing on monopoly and exclusive rights, and on the other hand, competition law, which is actually focusing on getting rid of those monopolies. How do we balance them within the European Union to give you a flavor, to give you an insight in the legal framework governing this issue? I will build my presentation up gradually, giving you an idea, first of all, about the industry, and in particular the technology-based industry, what are the challenges currently and what are the solutions for them. We'll then go into a little bit more detail with respect to intellectual property law, and we will be focusing on one particular intellectual property right, which is the so-called patent, which protects inventions. I'll come to that in a minute, and which is indeed key to the technology-based industry and to technology transfers. And I'll then come to the core of the discussion, and that's about the technology transfer legal framework within the European Union. Let's start with the challenges. Whether we are dealing with pharmaceutical industry, automotive industry, or even currently the food industry, which is getting more and more into technology, they're all confronted with the very same challenges. It's all about markets getting more dynamic. It's all about, as a consequence thereof, increasing competitive pressure upon them. That has all to do with globalization. Very simple example that we can give is a couple of decades ago, we would be competing within Belgium, the country where I come from. We would be competing regionally within the internal borders. When things grow and commerce grows internationally, you get a bigger market, but also a lot more players on that market. And when it grows globally, we are all competing on the European market for those 500 million consumers with a relatively high standard of living and high income. And not only the Europeans are, European businesses are actually battling for that consumer. We have also the Americans there, the Chinese operators come in, the Indian operators come in, and that means that through globalization, the market becomes very dynamic, and the competitive pressure upon those players becomes bigger and bigger. And that actually forces the economic operators to speed up their technological progress, to actually bring products and services faster to the market. Now, being confronted with those challenges, what are the solutions that these operators can actually use? I've tried to summarize them in this triangle, and it actually comes down to nothing else than to cooperate with each other. The bigger the market, the more competitive the market becomes, the more cooperation is needed to cope with them. We have cooperation, as is the case in your university, I'm sure, in the field of research and development. There is the cooperation in the field of production. You may well have an invention, you may well have a technology as a university, but you do not necessarily have the manufacturing capability to produce, to manufacture the given products. As a consequence, you will be cooperating with a factory that, on the basis of your technology, will be manufacturing, producing. And you may well enter into agreements with distributors who will be selling on the products on the market. So it's all about, again, cooperation in the field of production, in the field of distribution, for example. Another way of cooperating is cooperating in the field of technology transfers. And that's what we are now going to dig into a little bit more. And technology transfer is nothing else, for those who are legally skilled, is nothing else than licensing intellectual property. And licensing means that you give a right to use and exclude your exclusive right to somebody else. That is what intellectual property licensing is about. So we start with, for example, research and development. We get results, and those results is commonly called technology. those results may be protected by intellectual property rights, which are monopolies, such as the patent, but there are other rights, you see them there, a couple of them. Once you have that right, you give away, not really away, you give the authorization to somebody else to use it for the purpose of producing products, for example. This is the flowchart that gives you a summary of the various steps from research and development to production. And the next step is actually nothing else than getting those products on the market through distribution systems. But that's not the subject matter of today. We will stop with the production of contract products on the basis of intellectual property, in particular the patent. Now, what is a patent? A patent is an exclusive monopoly right that is limited in time and that is territorially restricted. In most states, you will get patents for 20 years, and it's an exclusive right that is granted by the state authority. That may be national, a Taiwanese patent, for example. It may be regional, a European patent, for example. And it's granted by the state for an invention. And an invention means a technical solution to a technical problem. I'll give you an example in a minute. That must be new, must not exist having been invented by somebody else before. That involves inventive step, ingenuity, that is capable of industrial application. I met a student over lunch who said that she wanted to actually do things that were useful and that could be used in the community, in the society. Well, that's what intellectual property is also about. It must be industrially applicable. It must become useful for society, and in exchange for your monopoly rights, you must make your invention public. You must disclose it to the entire world, thus allowing the entire world to build further on the innovation. So an invention is a new and inventive solution. Giving you an example, and maybe very, very simple, is this one, which is called the drop stop. What is the technical problem? Ask the waiter in the restaurant what the technical problem is. If he has a bottle of wine, has to serve it in the restaurant, and the customer has a nice white shirt, there may well be some red drops falling on the shirt, and this invention will avoid that problem from happening. It's the drop stop. So this is a patented invention. It solves a problem. It may also be a process, such as, for example, this happy fruit mix, which is produced thanks to a patented processing invention, and which allows the manufacturer to freeze pieces of fruit. What's the problem? If you freeze pieces of fruit, you will get a block of ice. It will take hours before you can defreeze it, and you get a result that is awfully to look at. When you use this technique, every single piece of fruit will be frozen separately, and as a consequence, when you defreeze it, you'll get a nicely looking fresh fruit salad. It will never be the same as an authentic made fruit salad, but it solves nevertheless an important problem, in particular in our countries where we do not have those exotic fresh fruits. That illustrates what a patent is, and once you meet the requirements, once you meet conditions to have an invention patented, you can get a certificate, let's say, that proves your monopoly right. I gave here an example of a European patent application. You'll get a number, you'll get a description of the given frozen fruits processing methods. What are the rights? What are the monopoly rights that you get whenever you get such a, you obtain such a patent? Well, you can prevent others from actually doing the same thing as you are doing. You can prevent others from making the given fruit salad, from selling, importing, internally using or storing the so-called drop stop or other inventions, so you get a monopoly right. What does it not grant as a right? It's not because you have that piece of paper, because you have those exclusive rights, that you also get a green light, a freedom to use by the owner. There may well be other exclusive rights out there that are patented and that may prevail upon your patent, and that you may need a permission to actually use those other mechanisms to produce your own product. So you may have to get into licensing in order to use your own patent. And what is it not either? It's not a clearance to market. Let me give you a simple example. It's not because you have a patent on an active substance of a pharmaceutical product that you can put that product on the market. Alongside your patent rights, you will have to obtain the marketing authorization through administrative authority proceedings. And you will have your patent on the one hand, and after clinical trials, you will get your authorization to the market. So do not confuse those two things. You need them both, actually. You better have your patent on the one hand, and subsequently your marketing authorization on the other hand. In summary, for innovation, a good knowledge of the patent system, a good knowledge of intellectual property system as such is pretty important to have. Let's now, our third building block, turn to technology transfer and the European Union competition law regime. So we're all convinced that a patent is important, it fosters innovation, but there are also risks. Let's first give you, for a good understanding, some insight in intellectual property right licensing through the example of monopoly. Everybody knows the game, the monopoly game. It's a very old one. What few people know, though, is that initially the monopoly game was indeed patented through a US patent. And how did it come about? There was a certain Mr. Darrow in New Jersey, I believe, who during the Great Depression in the 30s in the United States was turned unemployed. So he had a lot of time, he got bored, and he started conceiving a game to actually play in the neighborhood. He started conceiving the game Monopoly. And it was pretty successful in his neighborhood, and he thought, well, I'm going to see a game producer, the Parker Brothers. They may well be interested in my game, and as I have not the capital to actually produce many of these boards with the Monopoly game, they have the capital. We may well cooperate and get this this game manufactured on a large scale. And the first time he went to Parker Brothers, he was actually turned down. They didn't want his game because it contained 53 conceptual mistakes. So he went back home rather sad, I guess, but he had luck. There was a lady, one of the following days, who actually noticed the game. She got the game, and she was very, very fond of the game. And she happened to be the daughter of a Mr. Parker. And she convinced her father to nevertheless cooperate with Mr. Darrow. they improved the game and manufactured it on large scale and distributed it in the first stage at 20,000 pieces per week, which turned Mr. Darrow from an unemployed poor man into a millionaire thanks to licensing. Because Mr. Darrow, he licensed out his patented game to the Parker brothers for a defined purpose for the United States for 20 years. Therefore, Mr. Parker was licensing out his invention and Parker brothers licensing in against a royalty that made Mr. Darrow a very rich man. That is what technology transfer is all about. Now, what are the opportunities? What are the opportunities in the field of technology transfer, in the field of licensing? The opportunities relate to substantial economic benefits. And we come back to our first step in the building scale. It allows Mr. Darrow to share risks. The Parker brothers have the capital, he doesn't have capital. The Parker brothers take liability if something goes wrong, so there is a sharing of risks by cooperating. Mr. Parker does not have the capital, so he saves costs taken on by the Parker brothers. They are pooling their know-how. Parker brothers is in the gaming industry, know a lot of mechanisms, conceive a lot of games, and they launch together innovation faster. So all good things, but what's the risk involved? The risks involved is multiple. For the consumer, for the market as such, from the consumer side, there are a couple of negative, detrimental effects that may occur. There may be price fixing. They may agree that they will only put the products on the market for a given high price, which is bad for the consumer, for you when you want to buy it. Therefore, on the one hand, there is the intellectual property that generates innovation. On the other hand, there is agreeing on price fixing, or agreeing that we will only produce 10 games, whereas there's a large demand of hundreds who want it. What will happen? Prices will go up, obviously. Bad for the consumer. Something we do not want as a European competition authority, as a competition authority in general. So if these agreements, if these undertakings are inserted in a cooperation agreement between licensor and licensee, we will have a close look at it, and we will try to get rid of these anti-competitive effects. How do we get rid of these anti-competitive effects? Through our legal system, through competition law. So the negative effects of intellectual property law are actually coped with by another legal regime, competition law. And we have one article, if you're interested in competition law and interested in European competition law, the very first article you will have to keep in mind and you'll have to learn about is the Article 101 of the Treaty of the Functioning of the European Union, that's the TFEU. And what does it say in 2 words? It actually does nothing else than prohibiting agreements that appreciably prevent, restrict or distort competition within the European Economic Area. For example, an agreement where a contracting party prevents the other one to exploit its own technology. For example, if we would take our Parker brothers and our Mr. Darrow, and Mr. Darrow would say to Parker brothers, okay, this is the technology for our game, you have a similar technology being developed, you will now stop developing that one. That will decrease competition on the market, so that's not good. We do not want that. That's prohibited by our Article 101.1. What is the consequence? The consequence is voidness, non-enforceability of an agreement. So the agreement you made will be of no value to you. And not only that, you may well be subject to important penalties, to important fines. And the pharmaceutical industry knows that very well. The automotive industry knows that very well in Europe because they have been fined for millions, telecom also, for millions of euros due to anti-competitive behavior on the European market. But there may well be agreements limiting competition that when we are balancing their effects, their anti-competitive effects against their pro-competitive effects, that the pro-competitive effects are outweighing, are more important than the anti-competitive effects. And if that's the case, we actually accept such an agreement. We accept these anti-competitive restraints. I'll give you a couple of examples later on. Now, the whole framework within the European Union is fairly complex, but we have various legal documents that are guiding the industry, the business people, the lawyers, in assessing licensing technology transfer agreements. I've listed them here, the relevant ones. It's quite complex to actually read. They're all equally important, and you have for about 100 pages of literature to go through to assess your agreements. But we can summarize it on one slide. There are actually two, what we call safe harbors to get your agreement into, provided certain conditions are met. And it's fairly simple. If out there are at least 4 competing technologies that give the same results, that are commercially equivalent, we say that there is sufficient competition on the market and that therefore there is no issue about the monopoly, the intellectual property that is transferred, that is licensed. The second safe harbor is a little bit more complex, and I will be illustrating that one a bit further in the next few slides. The second safe harbor is or can be found in the European regulation and consists of a 6-step assessment. I've tried to make that as clear as possible on the slides. The first question we have to ask ourselves is, do we have a technology transfer agreement? What is it? What is our relevant market? Is it the entire European Union? Is it Belgium and the Netherlands? Is it including Germany or not? And not only territorially, we have to determine the relevant market as regards products, as regards technologies. Then the next question we have to ask ourselves is, are we competitors or not? If we are competitors, there will be a severer look at the agreement than when we are no competitors. The next question is, are there any hardcore restrictions? Meaning, are there any red flag, really prohibited clauses in there in the agreement? Then we have to ask ourselves, what are our market shares? A and B have a certain market share on that product market, on that technology market. If we are above a certain threshold, our agreement will be outside the safe harbor and will be scrutinized more severely. And the last question is, do we have any excluded restrictions? Orange flags. That gives you the flowchart of an assessment of a licensing agreement under European competition law. So the first step is, are we dealing with a technology transfer agreement or not? And a technology transfer agreement is an agreement between 2 contracting parties. Once we have 3 or more, we are not within this regulation, but we will be assessing by analogy. Then we will have to license technology. What is it? Well, it's, for example, a patent, a drop stop, or the processing patent, our fruit mix. But it may also be computer programs, it may be designs, the design of a car, for example, topography, semiconductor products, breeder certificates, pretty important for cattle breeders, for example. Maybe know-how, maybe copyright on software. It must be related to the production of goods or services. It doesn't matter whether they are intermediate or end goods. We are not talking about trademark licensing. Trademark licensing is outside this, the scope of the technology transfer, because trademarks is not really related to technology. It's about brands. It's about communication to the market through a given brand. So that's not technology. That's not about technology transfer. The next steps are, what is the relevant market, and are we competitors on it? The relevant market is determined by products that are used for the very same purpose. For example, two medicines that are meant to cure breast cancer, for example, may be on the same product and technology market. Are we competitors on that market? Well, if there is one producing a medical product, a pharmaceutical product for that disease, and the other one is also producing under another patent a similar product, they will be actual competitors on the market of the given medicine. Then we have to ask ourselves, as I said, do we have any hardcore restrictions, red flags? I have schematically presented there in red what cannot be in the agreement. To give you an example, the restriction of the possibility for a licensee to exploit his own technology is completely prohibited. The fixing of prices is completely prohibited. But there are exceptions. The allocation of markets is completely prohibited. But we can, for example, restrict a licensee to actively sell into the market of another licensee who is not a competitor at the moment of entering into the license agreement. And the reason for that is that otherwise that licensee would never invest in the product in the given market. So it's better to provide for an exception to the prohibition. Then we have to ask ourselves what are the market shares, and that will differ depending on whether we are competitors or no competitors. The threshold for competitors is lower than the threshold for non-competitors. If you are below the threshold, you're fine. If you're above the threshold, you're outside, and your agreement may be null and void. Then the last step are the orange flags, the so-called excluded restrictions. I'll just give you one example you may find in licensing agreements. It's the exclusive grant back obligation. So if you have a party A that licenses a pharmaceutical product, a technology for a pharmaceutical product to party B, and party B improves the given medicine, adds on technology to the first patent, then there may be an obligation to grant back the exclusive rights on the improving invention to the initial licensor. That will be, under the European competition law regime, a so-called excluded restriction, which is or may be null and void and will be taken out of the agreement. It's different from a hardcore restriction, the red flag makes your agreement entirely void, whereas the orange flag will only be taken out, will be taken off your boat in the safe harbor, but it will not have your boat sink. That's the difference between excluded and hardcore restrictions. Now, very briefly, a concrete example of the whole theory we have illustrated before. It may sound complex, but it's rather simple to apply, provided you know the rules. Here I have a market geographically consisting of 4 European countries: the Netherlands, Germany, Belgium, and France. We have 4 players. 3 of them are competitors in the pharmaceutical field and produce on the basis of their own patents. The first year, the market has a total value of 100 million euro, but they are not licensing to each other, they are not licensing to another party, in this case in Belgium. So on the technology market, we have no market shares, so we will be safe. Also on the product market, we will be safe because, as you see under the on this slide and the bottom of the slide, you see that the market shares of the various parties involved are below 20%. So no problem at all. However, in year 2, they start licensing, and you can see that there is a prohibition of active sale by B on the Belgian market, which in and of itself is not a problem, because we saw that it is an exception to a hardcore. But there's another clause which computes royalties on the entire turnover of B, and that will diminish the incentives of B to produce on the basis of its own technology. It's hardcore, and therefore the agreement between A and B will be void because it contains a red flag. And furthermore, there is another problem, because the market shares between A and B on the technology market in year 2 exceed 20% jointly. They have respectively 15 and 6%. And then you have an orange flag that starts to flag up and is warning you you're outside the safe harbor. You have 2 years to actually closely monitor your agreement, and if need be, adapt your agreement to the competition law regime. With this, I hope to have given you a flavor of a rather complex regime that balances intellectual property law on the one hand and competition law on the other hand, and that becomes, again, globally more and more important on the global market, because all authorities try to impose a system of, a well-balanced system between the monopolies of intellectual property and the freedom to compete safeguarded by competition law. And this illustrates the European way of doing that. If you are interested in a more in-depth understanding of this system, there is a small booklet that has been published a couple of days ago, and that it's in English, and it explains in detail, with all the guidelines in it, the European system, and it's downloadable for free from our website. If you can't find it, just ask me, and we'll make sure you can. You'll be directed to the link to the given publication. I thank you.
首先我简单的 summarize 刚刚那个Van Couter 教授讲的这个题目。首先，当然我觉得有点难，对大家来讲有点难，所以下 相关的这个细节，他已经出版一本书，就是鼓励说，你只要上他们公司的网站，你可以免费download。如果你需要签名版，那你就写 email请他签名给你。然后呢，他是外国的仲裁员，那他在他们的事务所是全世界非常大做财税方面。那刚刚讲的这个东西在谈，就是说，今天两家公司在做授权合约的时候，如果有不公平、违反竞争的事情发生的时候，是会不允许的。比如说，以前我替一家软体公司做事的时候，有一家美国公司出了1个billion的 US 要买那家公司，公司没有买，为什么？因为它是一个做全世界two shopping stories 因为那个公司呢，基本上它是做网管政策，然后它做网管政策呢，竞争对手来买它是谁？竞争对手买了它以后要不让它实行，这样它才能够维持它的软体在全世界的独占性。这样子就叫违法。如果我买了你是要让你目的不能够实施。还有接下来刚刚讲到的重点是什么？如果我们两家公司合作起来，我们两个是投资产业特权，市场超过了20%，不允许，因为这样会造成太大的影响。或者是假如今天我的技术透过淑美老师做了更好的进步，可是我是没有能力在市场实施的。那虽然说我在我个别领域我占了一定的市场比例，他也占了他一定的市场比例，但是没有造成比如说市场超过一半，超过什么？那这样子不会让消费者只能买到一种东西，价格变很贵，或者是没有其他选择，这样子是 OK 的。刚刚说的。那另外说，如果市场上有超过4种以上的选择，显然你有很多的竞争选择了，那这样是 OK， 就是他刚刚说的。那个OK 可以的条款，是不是我刚刚讲红色的、有橘色的、绿色的，对不对？那红色的就是绝对不可以，我们说我买了不让你做，我们加起来，比如说小米机加华为，那大家合在小米机加华为合并后，大家还有手机其他品牌手机可以用吗？大家没有吧？对，这样就不可以。还有，那另外就说刚刚他讲说，可是有些情况，他刚刚是不是举了例子？A、B、C、D 4个国家，对不对？怎么算市场的进步性？然后 A 他说 A 国家有1个产品 ，B 国家有1个产品，跟C 国家就是他们标准没有这2个产品。所以当这个产品要进来，这个国家是不是没有超过4种产品？可是如果今天国家很强，今天是德国，德国进来了，那德国这么强，每个国际说真的，为什么梅克尔做了这么多事，大家都一直提法国，不敢提德国？因为德国会把整个欧洲都控制住，大家很害怕。是不小心就被欧盟来调查，对不对？那Samsung发言了很多的专利，Samsung的手机的专利，等一下我们那个朱老师可能不知道会介绍到，不如有机会他会介绍。好，那 Samsung 跟 Apple 是打仗打得很辛苦，对不对？可是你要知道 ，Samsung 的专利都是 Apple 的几10倍以上，所以它的每一个领域里面都是几千件、几千件 ，Apple 都几百件、几百件。可是呢，因为它发言这么多专利，欧盟开始调查。Samsung 的过度发展它的技术，是会影响欧洲其他手机的生存，没错嘛 ？Motorola 就快要消失了，被谷歌买了，又被联想买了，好惨，对不对 ？Nokia 快要消失了，那这样的情况，所以它为了它区域的安全、区域的技术进步，为了消费者的权益，为了产品的多样性、科学的很多的理由，它会有这样一个法案出来。所以竞争法不见得是去妨害到了专利法的一个保护，而是它也是同样的促进了科技的一个进步。所以这是大概是刚刚这个整个的一个 summary。